I think we're ready to go. The next case is the case of Deutsche Bank versus Heinz. Would counsel please state their appearances?
I'm the appellant, Your Honor. So on behalf of Albert C. Heinz and Rebecca S. Heinz, I'm Ronald Wood with the firm of Clyde & Wood.
And Charles Kern for the appellee Deutsche Bank National Trust Company as trustee.
Okay, well, welcome, counsel. And as you probably know, today is a special day. It's Constitution Day. So we welcome you on this Constitution Day to the Kansas Court of Appeals. For those who may be listening on YouTube or watching live streaming, this is an appeal from a foreclosure and a judgment entered summarily by the Linn County District Court against the Heinzes and in favor of the bank. Mr. Wood is representing the appellant. As you know, you have 15 minutes. Each side does to argue. Would you like to reserve any of that time for rebuttal?
5 minutes, Your Honor.
So 10 and 5. And then just so you know, I think both of you know this, but prior to today, we've been provided and have read your briefs, and we've read pre-hearing memos that have been provided to us by our research attorneys. So we're pretty familiar with the facts. Certainly, if there's ones you want to reiterate, you can do so. But in the interest of time, if you want to jump straight into the legal arguments, you can do that as well. It's your option to use your time as you would like. But with that, Mr. Wood, you may proceed.
Okay. As indicated, I'm Ronald Wood, and I represent Albert Heinz and Rebecca Heinz. They have property in Linn County, Kansas. They had obtained a loan. I think the facts are in the documentation and the briefs. They had obtained a loan. The bank had obtained too much of a mortgage, had taken too much of the property, and they were asked to release it. And they had released that property. But I want to go through the issues that we have in the briefs. First off, it was the issue of the expert. The court struck our expert in this matter. The second issue was the reformation of the release and how that is tied in with the statute of limitations. And then the third issue was the court granting summary judgment in this case. The expert witness issue, the standard of review was an abuse of discretion. In this, the witness is to be a determination as to whether or not the witness is qualified. The witness was Michael Kerrigan. And Michael Kerrigan, and I think you should have a copy of his curriculum vitae. He had 4,700 different reports on real estate mortgage investigations. He had a Bachelor of Science degree and a Master of Science degree. And he got into areas that, quite honestly, like getting involved in medical cases. He was into issues that probably went over my head a lot, as far as what happens with mortgages and what they do and how they're sold and how they're divided. And so my client hired Mr. Kerrigan on these technical subjects and talked about the note, talks about the mortgage, talks about how these banks, what they do with their notes and mortgages, how they sell them, how they package them, how they send them on down. And we've seen that in cases, as far as whether or not they're backed by FDIC or by SBA or whatever. We see a lot of this technical things that we, as the people who are signing a note and mortgage, don't know what's going on. We don't know that it always gets sold. If it gets sold, sometimes we change where we have to send our money, but it is something that goes on that we don't always understand. Numerous courts have accepted Michael Kerrigan's opinions. Several courts had disqualified his opinions. I got to be honest about that. Is that that it had gone both ways. But
so how can we say it's unreasonable that no reasonable person would do it when some of the courts have said okay and some of the courts have said no? How could it be unreasonable?
I think the standard of review is abuse of discretion.
Right, which is whether or not any reasonable person would do it. You just told me quite a few courts, and we have those cited, I see in the briefs, have ruled on. Some have let it in, some have said no. It seems like that right there tells me that there is a legitimate, reasonable dispute of opinion as to whether or not his expert testimony should come in.
Well, if an expert witness was disqualified in one court, then by that analysis, you would say he could never testify in another court.
No, but it would be, you'd have to find another grounds for him to be unreasonable.
I just wanted the opportunity, because that was a major part of the case, an opportunity to have either a deposition taken of him or have the court listen, since she'd already kicked us out on the jury trial issue, that she listened to an hour of testimony to make a determination from that as to whether or not he was qualified and whether or not he had any kind of information that would be helpful, and whether or not the appellee really owned this loan and had the right and had any standing to move forward on this case.
Right. It looks to me from reading the record, what the district court was concerned with was not qualifications. I'm sure Mr. Kerrigan, I've seen his CV, and I think I've seen his name in other cases. I'm sure he's qualified and to render certain types of opinions. But the statute's a two-part statute. So qualifications is one thing. I may be qualified in all kinds of areas, but it also has to be reliable and relevant and helpful to assist the trier of fact. And I'm sitting here looking at the defendant's designation of expert witnesses, and he gave two opinions. The first one was the note signed by the Heinzes was split apart or fractionalized, and there is no proof the plaintiff has an interest in the loan at this time. Number two, the plaintiff does not own the mortgage and note, and therefore there cannot be any legal enforcement of the note. If I was a district court judge looking at this, these look like legal conclusions, and the experts on the law are the two of you as attorneys and the district court judge. And we don't need an expert witness to make those conclusions about whether or not they hold the note or not. That's what the court's to do. Why am I wrong on that?
Well, that's when I said it goes into issues in areas that I wasn't aware of. It might not be an expert on, and that it would be the issues of where are these notes sold, where were they sold, who held them at this point, and.
But hasn't the Kansas Supreme Court says whoever holds the note at the particular time can foreclose?
I believe so. Yes, Your Honor.
So it seems like they've answered that question. Now, whether they're right or wrong, they're a court above us that we have to follow their precedent.
We believe that it went to the weight of the evidence and not the admissibility, and that the proper decision in this case would have been to allow his testimony at this time, and to allow it in, listen to it, and then if the court did not give it that much weight, then that would be up to the court to decide.
Okay, well, we don't want to spend too much time on just one issue since you're limited time, so you might move on to the next issue.
Okay, I will, Your Honor. And then the other issue is the reformation of the release, the statute, and how that ties into the statute of limitations. Standard of review is a de novo review. The cases that I've cited is the Travis versus Glick case. It says the reformation cannot occur after the statute of limitations have run. The 5-year statute is what's applicable in this matter, written documents. And so it would run after 5 years. In order to do a reformation, there must be a mutual mistake to reform the document. There was no mutual mistake in this case. The mistake was only on part of the bank. They made the mistake, and there was no evidence of any kind of mistake on the Heinzes or any fraud on the types of the Heinzes. The error was made on October 16, 2009. 5 years later is October 16, 2014. This case was filed October 13th, almost 2 years later. So almost 7 years of statute of limitations on it. And so the statute had already run, and the court did not look into that issue as far as the statute of limitations and failed to find in the Heinz's favor on that issue, and never really allowed evidence or anything about any that's necessary is about any kind of a fraud on the Heinzes or any mistake by the Heinzes. And that's what's needed in order for a reformation to occur.
Counsel, I just want to stop you. Didn't the court make some findings with regard to equitable estoppel, though?
She did make some issues on equitable estoppel, yes, Your Honor.
And in fact, that's how she ruled against you on the statute of limitations defense, correct?
That's correct. That's correct, Your Honor.
So I want to take a look at those factual findings, and I just want to figure out which of these, or are you claiming that some of these findings are not supported by the facts, or what's your position with regard to those findings that were made on equitable estoppel?
Yeah, we don't believe that there was evidence of the equitable estoppel. So there was no findings of any kind of a mutual mistake. There was no evidence of a fraud on the landowners. The landowners, you know, if you thought they were intentionally trying to do something like that, they wouldn't have filed and asked for a change in the mortgage. And they were having financial difficulties, and they had filed for a modification of the loan in this case. And so if they were really going to try to do some sort of a fraud upon the bank, they wouldn't have went in and done a modification. There did come a time, though, when the landowners could not make the payments any longer. And so, you know, they continued to, you know, they did what they could do in this case.
So it sounds like because it looks like the district court found in particular that there was this error in the partial release that the Heinz were aware of, and the Heinz did nothing to inform the mortgagee of the problem. Are you saying that those facts were unsupported by the record, or are you saying that you disagree with that finding?
Well, I think the first off is that at the start, the Heinzes did not know about the release that had occurred. At some point, the Heinzes did find out about that, but they did not do anything about it. They didn't know anything about, as far as, of course, they're not lawyers, and so they don't know. And they attempted to try to represent themselves in this matter to start. And they did not know any kind, what that would mean, or have, you know, they just didn't understand what that would mean. They, by looking at the records at the Register of Deeds, I think they discovered at some point that the release had encompassed too much. And at that point, but they didn't do anything about it. I mean, they were continuing to make their payments. So it appears to me that they were somewhat of an innocent person as far as that was going on. It wasn't until
Counsel,
later.
I hate to interrupt, but just so I understand, but all of that testimony was submitted to the district court to consider, right?
Well, there was request for admissions and probably the depositions were submitted to the court. There wasn't any testimony or anything like that at the district court.
And I take it you denied that there was a mutual mistake before the district court?
Yes, we did.
Okay, well, I'll probably have questions for the Banks Counsel along those lines too. But one of the things I did not understand when reading this, though, is that at some point the Heinzes quit paying as if they didn't owe the money anymore. I mean, aren't we just talking about a mistake in the mortgage? Even if doesn't it just become an unsecured loan at that point and they still owe the money? They still owe the bank the money.
It'd be still owed under the note. It would still be
unsecured, right?
It'd be unsecured, yes.
Right, because just unilaterally stop paying, I mean, it's two separate issues. You may be correct. Maybe there isn't a mortgage that secures this, but
there's a promissory note. I do.
Okay.
I agree with that. There is a promissory note. If they own the promissory note, which they say they have it in blank, that the note would still be owed, but there would be no mortgage and it'd be unsecured.
Okay, so the real question is just whether or not it's secured or not. And the only way it could be secured is if the district court was correct in its legal finding about the estoppel, basically.
And the reformation and the estoppel, right?
Right.
That's all I have at this point.
Okay, well, thank you. Mr. Kern?
May it please the court. My name is Charles Kern. I represent the plaintiff appellee, Deutsche Bank National Trust Company. as trustee for Ameriquest Mortgage Securities, Inc., asset-backed pass-through certificates, Series 2005-R8, which I'll just refer to as Deutsche Bank. My attorney registration number is 23303. To address first the issue of the expert witness, Your Honor, Kansas law is clear. In order to show standing to foreclose, all you have to do is show that you're the note holder. You can do that by showing a note endorsed in blank. You can do that by showing the note has been specifically endorsed to you, or you can do that by referring to the UCC and its provisions on what constitutes a note holder. Expert testimony isn't required here, and it especially isn't required here when the Heinzes did not controvert the statement of material fact in the motion for summary judgment. The Deutsche Bank was both a note holder and was authorized to enforce the note and the deed of trust. They've already admitted that. The expert witness issue is a non-issue. And frankly, I'm surprised that counsel would still bring it up, because I provided him with a consent judgment from the Consumer Financial Protection Bureau, where Mr. Kerrigan has agreed never to testify in financial services matters again, or to provide reports on financial services matters. I provided those to Mr. Wood in August and asked that he withdraw that issue, but it hasn't been withdrawn.
Let's move on to equitable estoppel and tell us how there's a mutual mistake here and not a unilateral mistake.
The Heinzes assume here that there's a mutual mistake. They've assumed, but they haven't put on any evidence that the party that prepared the release of lien was Deutsche Bank. But that's not a fact that the court below found. That's not a statement of uncontroverted fact that we submitted. And the Heinzes have never actually—
So how can it be decided on summary judgment then?
Because the Kansas Court of Appeals has recognized that you can determine mutual mistake of fact based on the behavior of the parties after the document that you're looking at and trying to get reformed has been created.
So what factors here show mutual mistake? Sure. What would you hang your head on as if you gave me a list of like the top 3 factors on why we should say, yes, indeed, the summary judgment was appropriate, that there was a mutual mistake?
Right. I mean, the first one would be that it's the Heinzes who requested this partial release of lien. They discovered on their own that the mortgage over-encumbered the property. It encumbered 75 acres that was never intended to be encumbered. Second of all, that after they received the partial release of lien, and they admitted in their depositions, and the court has accepted below as an uncontroverted fact, that they received the partial release of lien in October 2009. And even after that receipt, for a period of 3.5 years, the Heinzes still acted as if the mortgage and the note were in effect. They paid monthly payments until July 2013, so that's a period of 3.5 years. Then, as Mr. Wood also indicated, they applied for mortgage assistance from the loan servicer at the time, which assistance was ultimately denied because they weren't entitled to it.
Let's walk through that. When did they get notice of the partial release?
October 2009.
09. When did they at least testify that they recognized and discovered that more property had been released than originally had been granted?
In their depositions, they testified that it was before they submitted the loan modification application to the mortgage servicer. They didn't specify a particular date, but they did indicate specifically that it was before they submitted the loan modification application.
So what duty did they have to bring that to the attention of whoever was holding this at the time?
Well, it goes to the factors that the Kansas Court of Appeals and the Supreme Court consider, which is a party's silence when it has material facts relating to a transaction, but withholds them and ultimately prevents the other party from taking action and prejudices the other party. That's what we're looking at here. It's the silence of the Heinzes, and also—
Well, I know that. First of all, when did the Deutsche Bank obtain this?
I don't know off the top of my head, but we have a date of assignment, I believe, in the assignment in the record.
But it was after all this, wasn't it? So somebody else held this at the time.
No, Deutsche Bank was still, I believe, the assignee, but there are mortgage servicers for assignees of mortgages. You probably heard some of them like Aqua Loan Servicing, PHH Mortgage Corporation.
Yep, familiar. We see those a lot. So what I'm trying to figure out is Deutsche Bank's one of the largest banks in the world. It's the largest bank in Europe. And you're telling me the two Kansas farmers lulled them into inaction? That's a little difficult for probably average Kansans to understand. So help average Kansans understand that.
Well, it's the nature of how this all played out. The partial release was provided to the Heinz in October 2009, and they figured out that, hey, it actually releases all the property meant to be encumbered, not just the 75 acres they requested. But then the Heinz has acted consistent with the note and mortgage still being in effect.
Well, they acted consistent with the note still being in effect, and it's still in effect to this day. They still owe the money. The question isn't the question really whether this is secured or not.
Well, I guess there's a two-part answer to that, Your Honor. The first is the Heinz's did not challenge on appeal the other basis the court below found for a lien that can be enforced through foreclosure, and that's equitable lien. They've waived that argument. The property can be foreclosed, and it's foreclosable under that 5-acre tract. So they've waived that and abandoned any argument as to that. So that's the first basis for the court to grant the motion for summary judgment.
Okay, so let's take that up, because I'm a little, as you can tell, concerned with your whole equitable estoppel mutual mistake argument here. Not saying that it isn't necessarily a winner, it's just that it's difficult to understand. Tell me why this could go ahead and be foreclosed under an equitable lien, because that might solve the whole problem.
Well, Your Honor, more or less the idea is that the motion for summary judgment sought in the alternative an equitable lien that can be foreclosed. The court granted the motion in the alternative as to the equitable lien. The Heinz's did not respond in the motion for summary judgment to that argument at all. And they didn't assert an appellate argument on the equitable lien. So that's why we think that the equitable lien argument moves forward. But also the equitable estoppel argument, Your Honor, there's also, addition to the Heinz's making payments and the Heinz's applying for modification, they also got the benefit of taxes and insurance being paid on their behalf. I mean, that the taxes and insurance are listed as escrow items in the summary judgment and in the— Counsel,
I want to interrupt you. Aren't those, I understand your arguments, but those sound a lot like the kinds of factual arguments that you would make regarding maybe contested intentions during a bench trial, not at summary judgment.
Well, I think the court also has to consider that plaintiffs entirely failed to meet their summary judgment burden here, Your Honor. Ultimately, they submitted no evidence of their own. There's not a single document.
But is there a requirement that they submit evidence, or is the court just supposed to look at the evidence that's submitted and say, does that evidence as a matter of law demand that judgment be entered?
Well, I think it's exactly what you mentioned, Judge Warner, but the evidence that was submitted by Deutsche Bank and which was almost totally uncontroverted by the plaintiff shows all these things. And if you look at the case of Farrell versus Farrell, you have the same kind of ideas of what it is that gets you to equitable estoppel, which is actions inconsistent with the document you're trying to reform. So
does it make any difference that Farrell was a family settlement agreement case and presumably equal bargaining power versus one of the world's largest banks and two Kansas consumers?
Well, yeah, I mean, I would say that, I mean, Deutsche Bank National Trust Company is not one of the world's largest banks. There are lots of entities in connection with that.
Well, I mean, the holding company is.
I don't think that sophistication of the parties necessarily applies here, Your Honor, especially when—
But isn't that a factor always in it? When you're trying to claim estoppel, sophistication and bargaining power, the equities, it's an equitable argument. The equities is exactly the issue, isn't it?
Well, I think the equities, though, favor Deutsche Bank because ultimately its predecessor in interest is the one that loaned the money to be able to purchase the property. As you can see in the lower court's judgment, more than $282,000 is owed on this loan. And if the court—
Well, they borrowed $225 originally, right?
Yes, Your Honor.
How much have they paid?
I could not say offhand, but what ultimately happens is that because borrowers don't pay for long periods of time, interest and fees and charges accrue under the deed of trust in the note. So that
No, but
number-
you were just saying the equities about the house. I mean, they've paid, I mean, I think I saw on the record, they've paid a pretty substantial amount. So it's not like a case like some of them we get where they pay nothing. I mean, they paid for a long period of time.
Right, but what was bargained for was a lien on the property that can be foreclosed if they don't pay. Because as the court has indicated, notes are unsecured. So, the next thing the borrowers would do after, finding out that the lien was unsecured is go and file bankruptcy to have that amount discharged or at least pay reduced amounts. They didn't do that here, but ultimately that's where the equity comes in, because it is the bargain that is struck. For borrowers to receive the money, they also have to agree that if they don't pay, the property is foreclosed.
Okay, who actually put the wrong legal description in the partial release?
There's no evidence to that, Your Honor. There's an attorney name on the partial release, but there's no evidence who that attorney was an attorney for, whether it was both parties, whether there was either. And that's the assumption that.
So if there's no evidence on that, how can I conclude, or we conclude, that this is a mutual mistake without findings of fact?
Well, yeah, there are findings of fact. And as I've indicated, the Kansas Court of Appeals, I believe it's the Chamberlain case we've cited, says that you look to the parties' behavior, because finding mutual mistake is not necessarily about finding contemporaneous documents or evidence. It's about looking at the behavior of the parties after the release of lien.
Well, isn't looking at the behaviors something that would be fact determinative, that you would need to have a hearing and look at those things versus summary judgment as to, I'm having a lot of trouble with this being a mutual mistake. It may have been, but it seems to me that there's just not enough here to say as a matter of law, this is mutual mistake. You just told me we don't even know who made the mistake. So how do we know it's mutual?
Well, because the way you look at mutual mistake and the evidence you consider is the behavior beyond the document you're trying to reform. And there is uncontroverted evidence of that behavior in the motion for summary judgment. I mean, ultimately, you can't not meet your burden on a summary judgment and then try to attack the facts. And Mr. Wood says, we didn't get the chance to present testimony or evidence. Well, that's not true. He had the chance in the motion for summary judgment, just didn't do it.
Counsel, isn't it also that, but you can also say that even if we assume that these facts are true, these facts don't get us to summary judgment, right?
Well, yeah, I mean, I think if you look at the Chamberlain case, I think if you look at the Farrell case, that the facts do get you to summary judgment, because it's enough to show that the Heinzes were acting consistent with the release, maintaining an encumbrance on the 5-acre tract. That's what the facts are consistent with, and that's what the courts have looked back before. What are the facts consistent with? So ultimately, you have a mutual mistake, because both parties are performing like the release only released this extra 75 acres that wasn't meant to be.
What due diligence did your client use to try to discover this? Obviously, Mr. Heinz was able to find it, and whether it's sophisticated or not, a financial institution represented by attorneys couldn't find it. What prevented? How did they lull your client into doing anything?
Well, yeah, again, that's the acting as if the loan is completely valid and
how did they act that the loan is completely? You keep saying that. Then they just make payments and they owe the money. So how does that show you say the loan? Let's talk about what we're talking about. We're talking about the mortgage. What did they do to tell the bank and to lull the bank into saying the mortgage is still valid after the release signed by whoever was holding it?
Well, yeah, I think the payments and asking for mortgage assistance are both indications that they acted that way, but also the servicer of the mortgage, and you can see this in the payment histories, you can see this in the judgment, was paying taxes and insurance on the property. The Heinzes were accepting the benefits of that. Taxes and insurance aren't necessary for an unsecured note.
And how did they receive a benefit? Isn't it just their money that you're passing forward?
No, Your Honor, it's under the loan documents, it's the servicer that makes those payments. And those payments of taxes and insurance are added to the loan debt.
Right, they're rolled into the debt.
But
so they're making the payments ultimately. It's just you're servicing it.
Well, no, and they stopped making payments, and the taxes and insurance continued being paid after they stopped making payments. Ultimately, those are
So
the
if
factors.
you're telling me that if Mr. Heinz had not discovered this, what would your argument then been? That if he had not discovered the mistake in the partial release, that I'm not sure. I mean, the fact that he discovered it later seems to tend to go to the fact that it wasn't mutual, that it was unilateral, and he discovered it. I mean, that seems to be your argument. It was unilateral mistake. He discovered it, didn't tell us, therefore he lulled us into lack of action.
No, I mean, I don't believe that's our argument, Your Honor. He discovered it, but he was silent after he discovered it, and that's the same.
What if he hadn't have discovered it? What would have been the ramifications?
If he hadn't discovered it, I don't know. I mean, that's not the fact pattern presented to the
Would you
appellate.
still have argued it was a mutual mistake had he not discovered it?
It's entirely possible he still would argue it's a mutual mistake, even if he hadn't discovered. But that factor that he did discover it, he admits he discovered it. He admits he discovered it before he applied for mortgage modification. That is one of the factors that goes into the equitable estoppel argument. So
It seems like this is a fact-dependent argument, but okay, you're at 16 minutes, so go ahead and wrap up what else you'd like to bring up.
I'll just stand on the brief and the issues. I believe that many issues have been waived by the Heinzes, including the fact that the note is existing, that the note has a balance, that the note, and that there's a judgment against the Heinzes, but also that the equitable lien argument has been waived by the Heinzes by not bringing it up, not addressing it on in response to the motion for summary judgment too.
Counsel, real quickly, before you right off into the sunset, I want to ask one question on that point, and that is, so on the equitable lien point that you just made, are there different facts that you set forth that would support that, then support the equitable estoppel claim?
Well, the different facts would be about I mean, they're all in the uncontroverted facts, but the different facts would be in the addition of the fact that the loan was obtained, that the money was provided, the taxes and insurance were paid, those kinds of things.
Well, and the fact that all their documents say that they were getting the loan, even their loan modification for property located at 10748 Rice Lane, Pleasanton, Kansas 66075. That seems like a better argument than to try to blame them for this release that somebody we don't even know who made a mistake on. But we'll consider it and see where we go. That's why we have 3 judges. Mr. Wood, you might want to address this equitable lien argument, because if you didn't respond to it at all, that could be a problem.
First off, I wanted to say is that this property was in several generations, so the appellants were not interested in losing this property at all. But and they had paid over the time, they'd paid enough, $225,000. They'd already paid enough for the amount of the original loan. But you'll see that the most of the what we have now at this point is interest and additional costs and other things that have been added onto it, insurance and taxes and things of that nature. So that is, I think, one reason. I think they were trying to pay what they could, and that's why they asked for that loan modification. There is no mutual mistake in this, and there weren't. The court didn't allow anyone to even make those determinations or put on that evidence as far as a mutual mistake. As far as an equitable lien, we were of the belief that the statute of limitations applied regardless of whether it was what kind of a lien it was. There's 5-year statute of limitations. They made a mistake on it. They come back and want to do a reformation, and it's
well, it makes sense. Didn't it, Mr. Wood? Didn't it? I mean, I'm trying to think practicality, real life here. The reality of it is they knew very well what they were. I mean, this thing was messed up from the start. The original mortgage had the legal description wrong one way, then it was wrong the other way. Since we're in a court session, I won't tell what type of mess I think it was, but this was quite a mess from the get-go. But you don't disagree that the intent of everybody has always been for them to borrow money to purchase a home at 10748 Rice Lane, Pleasanton, Kansas, 66075. Which is where they lived and maybe still live.
They don't.
Correct?
I don't think that they are able to live there because of some damage that occurred to the property because of a water main break. But they do want to keep the property. And they purchased it from Rebecca Heinz's family, so it had been in the family for quite a while. That's how they got the mortgage. I think the mortgage is one of these online, when you get these mortgages online and you don't, they back at that point, they were getting these mortgages right and left easy. You could get loans easily. And I think they just continued to mess up the paperwork in this particular case. As far as the lien, we just felt that they didn't have a lien because they'd released that. The statute of limitations in 5 years had run, so therefore that was not good. Their arguments were that it was an equitable lien, but they didn't have a mutual mistake. And we couldn't figure out why they continued to say there was a mutual mistake when there really wasn't. The mistake was on them, and they're the bank. I mean, surely they do title opinions, and surely they do something that would indicate, what was right or what was wrong with this matter. And we just want a chance to go to in front of the
Counsel, real quickly before you do that, I'm looking at page 15 of the district court's summary judgment opinion, and it says, just at the bottom of that page, the court adopts the arguments of the plaintiffs and finds in the alternative that it holds an equitable lien on the property that can be enforced through foreclosure. Did you appeal that finding?
I think I appealed the whole lien. I think I appealed the lien altogether, that by the mutual mistake. I mean, I think they get that through. The court finds as follows: it is clear and undisputed the defendants intended to encumber the 5-acre tract of land as collateral, is what she says. They've not.
Well, you don't disagree with that. Wait, Mr. Wood, you don't disagree with that, do you?
No.
I mean, that was clearly the party's intent. Now, maybe this partial release was like manna from heaven, but that was always their intent, wasn't it?
Yeah, yes, it is. But what good is the statute of limitations if we don't enforce the statute of limitations? If they make
well, I'm not questioning that. But what I'm just saying is we're not questioning the intent here. The intent of the parties is pretty clear, and I think that's all the district court judge was saying here.
I think
the intent's pretty clear on what these parties wanted, and maybe by the grace of the good Lord, manna from heaven bestowed upon them through a partial release that ended up being a release in its entirety, but we don't disagree on the intent.
She just
the question is, was that appealed, and could we meet the factors of equitable lien even if we don't meet the factors of equitable estoppel?
She just says the uncontroverted facts, the mistake was mutual and common to both parties. And we just said we don't agree with that. We've appealed the whole decision from the court, and we've appealed on the issues of the reformation of the release and the statute of limitations, which we felt covered that area of the equitable lien, and also this issue of the summary judgment, in that we thought for summary judgment was premature. We thought that it should have been allowed to go to trial. Even with our expert witness, we should have been allowed to have that person at trial. But if the court says, okay, that's not allowed, then we needed the testimony of the Heinzes. And one thing that hurt in this case is that the Heinzes were pro se early on in this case. And they had done some of their requests for admissions and had got those admitted. Didn't understand what they were doing. I got into the case after they had got into some problems on the thing, hadn't done their discovery. And I think if we're talking about equity, the equity is that the Heinzes got kind of bamboozled, as it was, on the discovery, and had to admit things that they couldn't withdraw back from.
Whose fault is that, though? That was their choice to proceed on their own.
I understand, Your Honor, but I think people get involved in these that are laymen who don't really understand how complicated it is, how much time it takes. This file's got, I don't know, 2 or 3 boxes with it. So, I mean, it's not been an easy case to defend.
I certainly understand. And any other questions from the panel? With that, I'd like to thank both counsel. You made good arguments and we appreciate those. I will remind you that Kansas law favors settlement. There's no reason why you couldn't settle this action before we issue an opinion, but it's our job to issue an opinion. Bad facts make bad law, as you know, and we've got some really bad facts here. When you've got a mortgage that was initially messed up, you've got a partial release that we clearly was messed up. So just remember that as well. But do what you want to, because within 60 days, we're going to try to get an opinion out to you. But if you can get it resolved before then, let us know. Thank you both and good luck to you.
Thank you, Your Honor.
Thank you, Your
We'll
Honor.
just stay on the line here.
Okay, I'll get out.
Thank you both.